Can I have a TOD on my Michigan business? Well, TOD, hopefully you know, means transfer on death. The idea of essentially having a beneficiary designation on my business, similar to what I might do on a bank account or on a life insurance policy, on my 401k, etc. Can I take my business and have a TOD designation on my business? Why? So that it too will avoid probate. As discussed in previous episodes, the whole point generally of a beneficiary designation, be it beneficiary, TOD, which is transfer on death, POD, which is payable on death, all of those are used to accomplish a primary strategy for many clients of avoiding probate at the time of their death. Because if you have a TOD, then at the time of death, whatever asset has a TOD designation automatically goes to that person or that entity. So many of you, business owners, many of you are going to have a trust as part of your estate plan. And so the question is, when do you transfer ownership of your business into the trust? Perhaps you have an LLC set up. Maybe that LLC has been set up for rental properties, which is a very common usage of an LLC today. Or perhaps it is a different business that you're operating under an LLC, or perhaps, just like myself, your business might be set up as a corporation in the state of Michigan, perhaps a subchapter S corporation. But whatever that legal business structure is, under Michigan law, a company can have a designation set up and registered so that at the time of death, that business interest transfers, avoids probate. So let's look at if you have a trust. If you have a trust, one option that oftentimes is done by clients is they will transfer the business interest today. Today, we'll prepare a transfer of stock. Today, we'll prepare a transfer of the membership interest and transfer it outright. But sometimes that becomes more complicated during lifetime, and the trade-off might not be worth it. So, for example, under Michigan law, owners of the companies can, and under certain conditions, must approve company action by written consent. That's what the law provides in Michigan. Well, if your trust is the owner of the business, and let's take that one step further. If you're married, that trust is likely a joint trust with your spouse. So now you and your spouse are serving as trustees. Perhaps you're the owner of the business, but you and your spouse are the trustees of the trust. Well, now, if you transfer the ownership interest to your trust now, and if the owners of the companies must provide written consent for certain company action, that now requires your spouse as well to sign documents. So we're simply complicating, adding to the number of people that now have to be involved in signing that paperwork. But more importantly, perhaps that might not be as complicated, but sometimes you're going to be dealing with third parties, maybe insurance companies, maybe the LLC or the corporation is borrowing money, so you have lenders involved. And in that case, you will likely find that the lenders or the insurance companies are also going to start requiring signatures by all of the owners, which again, in this example, is going to be both spouses. And they might now want a copy of your trust documents so that they can review them and make sure, or have their law firm review them to make sure that, in fact, the trust can own the LLC or the trust can own the corporation before they're going to issue that policy of insurance or loan that money. So again, We're just complicating the operational sense of the business when you're dealing with third parties. And you might already have certain company documents that provide for options or rights to occur upon the death or disability of a shareholder, such as a buy-sell agreement of a corporation. And now if you have a trust as the owner, and I've seen this many times where someone wants to make their trust the owner of their shares of stock, but when you read through the current buy-sell agreement, the language that's being used in the buy-sell agreement was not based upon the concept that the stock would ever be owned by a trust, and because of that, there were complications that would have arisen but for now having to actually amend the corporate documents in order to make that happen. So bottom line is sometimes we've had situations where somebody wants to add a trust as an owner of their membership interest in the LLC, or wants to add a trust as the owner of their stock. Documents need to be changed in order to accomplish that. But that goal of avoiding probate is what you're trying to accomplish. But now we're looking at during lifetime and saying, well, if you do it during your lifetime, we might be complicating, if you will, the operational end of the business. So perhaps under those circumstances, it would be better if you could simply have your business conducted the way that it's conducted now. The same number of people have to sign things now, but you have the advantage that at the time of your death, that's when we want to make sure that the business is now owned by your trust. So in that case, having a TOD to your trust keeps the business operating as it is now, keeps you, if you will, under these circumstances, the sole owner of the business, the only person that needs to sign documents, etc., yet avoids probate by making your trust the TOD, the beneficiary of that TOD, at the time of your death. Now, another example, maybe your estate plan is that you're going to transfer your business interest to a child. Well, in that case, we have to look, maybe it doesn't really make sense to transfer it first into your trust, to then transfer it from your trust to your child. It might be better, and again, circumstances all have to be evaluated, but it might be better to simply have the child as the beneficiary of the TOD. A TOD doesn't have to be a trust. TOD could be your child. So in that case, the traditional idea of putting the putting the business in the trust, then having it go from the trust to the child as the way to avoid probate, well, you might be well served. It might accomplish all of your estate planning goals to simply have the child the beneficiary on that TOD and bypass the trust entirely. Now, certainly one advantage of that is that you could still maintain control if that's what's needed until your death. Maybe you're going to be under a circumstance where you're going to give some partial interest to your child during your lifetime, but you're looking and saying, hey, I want to maintain control of this business until my death. Maybe the way to accomplish that would be to have a TOD directly to your child as part and parcel of your estate plan. A number of things obviously have to be factored into that. One of those, not the least of which, is, well, what if your child dies before you? What if your child dies before you? Then where is that business going to go? And then you're looking at an alternate beneficiary designation as part of that TOD process. And keep in mind, too, though, that if you have a child receiving your interest as a TOD, they're not buying it. They're not obligated, for example, if they have siblings, to pay their siblings for whatever interest they obtained in the business. So factoring in, if you're like so many clients who want to make sure their children are treated equally, that in and of itself would avoid probate, but it's not going to negate the need to otherwise consider the value of that business interest that the child is receiving, so that the balance of the estate can likewise be adjusted if that's what you want to do, so that everyone receives an equal share. But it is another option. In lieu of transferring to a trust and then transferring to a child, it can go outright. Now, again, good news. Michigan law allows that to happen, allows a business interest to be registered in TOD form. And obviously, again, naming the TOD beneficiary, it doesn't affect the ownership of the business until your death. And then upon your death, it's going to automatically go to the designated beneficiary. Some caveats, though. Caveats. One, the TOD is only going to apply if your business is structured as either a corporation or a limited liability company. Why? Because banks, generally speaking, if you have a DBA, just you doing business as, and you haven't set it up as a corporation, you haven't set your structure up as an LLC, most banks that we come across do not permit beneficiary designations on a business account. So if you can't have an account at the bank that you can transfer to somebody by way of TOD or beneficiary because it's a business account, then the DBA that you set up at the county is not going to be a business structure that's going to enable you to well transfer the business. So you're going to, in that case, have to convert the business to either a limited liability company or a corporation. And there might also be other reasons for transferring that business to a limited liability company or a corporation. In general, just in general, passing an LLC or a corporation to somebody at the time of your death is much easier than transferring a DBA. So if you look at, and we could have a whole episode on business succession planning. I teach a course at Farm Bureau on business succession planning. And oftentimes with the business owner, when we're looking at putting together a plan for what's going to happen with the business at the time of death, when we look at the current structure, if it is simply set up as a DBA, many times, certainly if clients want the business to continue after their death as an entity, they don't want it to simply be closed and have the assets sold, converting that business structure into either a limited liability company or corporation is going to be part of that process in order to accomplish that. So if you've got that corporation or LLC and you want to have your membership interest subject to TOD or your stock subject to TOD, what do you have to do? Well, your business documents, and that's going to be the controlling documents inside your business. It might be your LLC operating agreement. It might be in your corporate buy-sell type agreements. You're going to have those documents drafted in order to first permit a TOD designation. It's not automatic. Michigan law says you can do it, but if you don't designate it in your corporate documents, it's not going to be available. So first, whatever business documents, relevant business documents for your business are going to have to permit the TOD designation. Those same business documents are going to have to provide the procedure for how do I designate a TOD? What form am I going to be required to use? Again, all spelled out in the business documents themselves. And as importantly, the business documents are going to now have to provide the procedure for processing the TOD at the time of the owner's death. What do I have to provide, or what do my survivors have to provide to the business? Is it simply a death certificate? Is there going to be, think about, a life insurance policy. when you're a beneficiary on a life insurance policy, you don't simply call the insurance company and say, hey, we'll send you a check. There's a process. There's a form. You have to provide death certificates. You have to fill out a beneficiary claim form. Similar idea needs to be determined inside of your business documents so that when that does happen, i.e. your death, there is a process, there are forms, everyone knows what it takes in order to accomplish that transfer on death. Now, if you're just setting up a business and you are now in the process of creating those documents, that is certainly the time to work with your attorney and consider the possibility of, hey, should we have provisions in here for TOD of our interest in the business? If you already have a business and you already have documents, now your attorney is going to have to look at those documents and determine what needs to be done to change those documents, i.e. amend those documents to accomplish those goals. And think about this too. If you already have other members of your limited liability company or other shareholders in the corporation, it is likely that in order to change those documents, everybody is going to have to agree. So it might not be as simple as saying, hey, I'll just do this. You might have other vested interested people, i.e. other members in your LLC or shareholders that are also going to have to be on board. Now, the question for other members, does it not benefit them as well? If their goal is similar to your goals, avoiding probate, it might benefit them as well in agreeing to have TODs available. Now, you might still have inside your corporation or your operating agreement where you're limiting who the stock can actually go to, or you're limiting who your membership interest can go to, which oftentimes is part of a buy-sell agreement where you don't want the stock to end up perhaps going outside the family or the membership interest going outside the family. You can still have those similar restrictions. It's simply the process for accomplishing the transfer. So the fact that you allow TOD doesn't mean you have to allow TOD to anybody. You can still have the sorts of restrictions that you might be already familiar with, but it's something that needs to be done. So if you're interested, if you look at this and say, hey, why don't I consider having TOD on my business rather than putting in the trust now? If I've created a trust, or maybe I don't have a trust, but I want the business to go to a child or to somebody else at the time of my death, talk to your attorney about what it would take to restructure your documents in order to make that happen for you. And of course, goes without saying, though, that if you're not already working with an attorney or your current attorney isn't interested in doing that, contact us. Contact Amanda and myself, and we can talk to you about how it is that we would be able to help you as part of your estate plan and what it would take to restructure your business documents to enable you to have a TOD on your business.